our IPA.
Yes, sir.
So today we are covering the inspection and grievance. I think this is the most hot topic because every IP is concerned with the grievances. Every IP has grievances with IPA as well as with IBBI, as well as with NCLT and as well as with the DC also. So we should start now. Nitika, kindly share the regulation, then we will cover.
Okay, so firstly, shall we discuss inspection regulations, sir?
Yeah, inspection regulation.
Okay, just give me 1 second.
Sure. So how is the Josh, everyone? IP profession.
Yes, sir.
Very
Good
challenging.
afternoon. Good
Josh,
afternoon.
good afternoon, sir. Good afternoon. Josh ढीला लग रहा है थोड़ा.
Challenging, challenging.
Good. Yes,
with
sir.
with monsoon session approving so many amendments, I think that Joe should be back, sir.
That's great. That's great.
Yeah,
But
we are
pray,
optimistic. Yeah.
yes, pray to the God for the smooth functioning of the parliament session.
Yes, sir. Yeah, the way it has started, I think the signal is not very favorable.
Yes. As usual.
Yes, sir. Yes, sir. Thank you, sir.
Sir, now we are covering starting from the Insolvency and Bankruptcy Board of Inspection and Investigation Regulations that came in 2017, and after that it amended. Latest amendment was on the month of June 2022. So we will cover, as usual, we will cover the regulations. So any suggestions in regulation 1? Regulation 2, kindly share your views. Here I have some suggestion in definition of disciplinary committee. Here, as of now, we have only disciplinary committee with the IBBI and having only the one member. It means whatsoever that member will decide will prevail, and earlier there was no provision for the appeal against that decision, and we had to go before the High Court and seek the justice from there on. Now, after the amendment, NCLT has been empowered for an appeal against the disciplinary committee order. So in my view, in the definition of disciplinary committee, there must be some third party involvement in this committee also. So I want your suggestions ki what should be there under disciplinary committee, because this affects the decision of disciplinary committee affects all IPs. So in my view, there must be some practical approach adopted by the DC. But in previous judgment, it has been observed and seen that practicalities was not there in the order of the disciplinary committee. So now it's my humble request to come forward and give your valuable suggestions.
Third party means who should be there in the disciplinary committee?
Yes. See, right now only the disciplinary committee, only whole-time member of the IBBI is there.
Sir, I think this committee should have 3 members, one from the IPA and one from a panel of experienced IP, those who have the practical experience of being in that situation and how things are implemented and executed.
Okay, very good suggestion, Arvinder ji.
Sir, I also subscribe to what Arvinder ji said. See, you need to have some experts, who understand. Say someone like from the people have experience in arbitration or similar, who understands the the recent judgment which has come in the case of Mr. Sarkar. They are
Yes.
talking about, giving an opportunity for hearing, natural
Yes.
justice. These are the very common things.
Exactly.
Could also be there, sir, in any internal discipline. See, I have handled these things in my own employment for many years, and these are the things have to be present. So, उसका एक representation sir चाहिए. वो तीनों members में एक आदमी जिसका उसमें तजुर्बा है, that person must be very important. This will give a lot of holistic outlook to the subject
Very
of.
good. Now there are, as suggested by Mr. Harvinder, one person from the IPA, but there are 3 IPA.
Pankaj, I suggest that there should be an outsider also. Outsider means like, a judge, a retired judge, or maybe, senior advocate, or maybe, NCLT member or some independent, person from outside. He should also be a part of,
So
the committee.
in my view, that's your suggestion is highly practical. In my view, there must be some representation from IP community also, one person from IBBI, and as and when case come, disciplinary committee should be formed accordingly. Shyamji, kindly mute your. In my view, as and when the case comes, then disciplinary committee should be formed accordingly. So there must be one person from the IP community, one person from IBBI, and one
from banking community.
Yeah, and one from the legal community who will head the committee.
Legal is mostly covered from except other committee fields like
Yes.
banking.
We can take any retired district judge, any retired NCLT judge, whosoever it may be, any technical member from the NCLT team.
Yes, Pankaj,
yes, sir. Oh, एकदम बढ़िया रहेगा,
Yes.
sir.
So
Thank
there
you.
must be some representation from that angle also. So next suggestion, Nitika, come down.
The
Electronic
committee
form.
should be rotational in nature, sir.
Yeah, as and when the committee needs, then accordingly we can change the IP. We can change.
Pankaj sir, can we discuss here? There should be an appellate authority also. Appeal against the order of the disciplinary committee.
Sir, that is an anklet is there, na?
नहीं, disciplinary committee के against में anklet नहीं है.
Anklet is there, sir.
See, the order of disciplinary committee is not being entertained by the NCLT.
Sir, I think I read somewhere.
No, sir.
Now
sir, everybody who is aggrieved, they are filing writs only.
It should be on the same lines as Board of Discipline and Disciplinary Committee.
There must be then NCLT or NCLT. I think it is in discussion paper. Something is there. Let's see.
Whether they are going to do it.
Yeah, they are going to do it.
But anklet is basically only for the appeal against the order of the NCLT, I think.
Yeah, let's see. But some suggestions are going on in IBBI.
All right.
Then investigation authority. Any suggestion? Inspecting authority and investigation authority.
It should be multidisciplinary.
What's the difference in investigation and inspection? First, we have to find out this. Any view?
Inspection is just a routine matter of going through the compliance of procedure, and investigation is on the basis of some complaint or something which has come to a motto or by somebody.
Right.
So it means that authority is not permanent. As and when the need arises, then investigating and inspecting authority will be formed by the IBBI. So, but there must be some thing on the public platform who are the members of investigating authority and who are the member of inspecting authority of the IBBI. I don't think there is anything on the IBBI website. Who is under the investigation authority? Who are the members of the inspecting authority?
I don't think it will be accepted.
Let's see, sir. Our work is to give the suggestions.
Sir,
Yeah.
sir, it keeps on changing with every inspection. So it won't be possible to publish the names on the website. So generally what happens is for every inspection and for every investigation, the officers keeps on changing.
But there must be some authorized person, 5%, 10%, 20%.
Maybe.
That is like based on the cadre of the person.
Yeah, based on the cadre of the person. There we have to specify ki minimum cadre of employee shall be there. AGM, GM.
Like deputy commissioner or
Yeah, AGM, GM,
on the
CM.
same line.
Something should be there. Anyway, now come to chapter 2nd. I don't think anything required under this other definition. Any suggestions? Next. I think it's well defined. Next. Kindly share your views openly. Here, conduct of inspection, at least 10 days notice is there. It is sufficient, or there must be some amendment?
Pankaj, 15 days notice, I think.
15
bare
days.
minimum. 15
Okay.
days bare minimum.
Yeah, I also think 15 days.
Conduct of inspection, 15 days notice.
15 working days.
Yes, 15 working days.
Yeah, the word working days is very important. And
Exactly.
it should be not less than 15 working days.
I'm
It could be
100%.
more.
I am 100% agree with you.
Pankaj sir, as far as possible, it should be avoided कि भाई आज मेल आया और 48 hours के अंदर या 24 hours के अंदर reply करिए उसका.
नहीं वो see we are covering inspection. Shyamji, right now we are covering inspection part. So that we will discuss under our grievances chapter.
Okay, okay.
Anything else in this regulation 3-4? Regulation 5. I think where the days has been mentioned, so it should be 15 or 10 working days in spite of days. What's your suggestion?
Up to 30 days, it's okay. It should be working days. Beyond 30 days, it can be days only.
Pankaj, it should be working days. They should specify working days.
All working days now.
So could you scroll up a bit? Is there a timeline specified for the, for completion of the inspection? It should not so happen that it keeps on, going on for a long period in time.
Yeah, true. There should be some kind of a time frame.
Yes. Maximum upper limit should be there. Inspector.
Also there should be a time frame.
That is there. That is there. Within 15 days, they have to send the interim inspection report, and within 15 days of sending the interim inspection report, they have to send the final inspection report.
Copy of report will not be shared with the party.
To the service provider, ma'am.
No, inspection, if they are inspecting somewhere like a IP's office or something, then the copy of the report will be submitted only to the board.
No, inspecting authority shall send a copy of the draft inspection report to the service provider. They will send us the draft report, and they ask our comments on their observations. After submitting our comments, they will finalize the draft inspector. They will finalize the inspection report.
Okay, sir. Thank you.
Next, investigation.
But final report is not shared, I think, sir, with the
Yeah, final report is not shared, but in inspection, we should mention that there must be an upper limit of submission of the final report to the board as well as to the service provider.
Right.
We can mention that within 30 days of submitting of the comments from the service provider, the inspecting authority shall submit a final report to the board as well as to the service provider. All are agree?
Yes.
Next, investigation. Kindly give your suggestions. See, under investigation, timeline of conducting investigation is there. Subclause 3 of regulation 3. Subclause C of regulation 3. In the same way, there must be something in inspection regulations also.
Yes.
Any suggestion in
So
regulations?
I had a query. So basically, what should be the linkage between inspection and investigation? So typically, investigation might be followed pursuant to the inspection. Let's say,
Inspection. Yes.
and not independently. So
No, it can be independently. If some complaints has been received by the board, then they can directly investigate the affairs of the CIRP of any company.
okay, so that is one case. And if the findings of the inspections are also
Inspection report
adverse,
is there, then they for further digging the things, they can go for the investigation.
Investigation
Is some sort of financial irregularities or some fraudulent activities like this.
investigation order must mention the reasons for investigation.
Exactly. Conduct of investigation, regulation 8. Here also 15 working days. Timeline 10 working days, 10 days ki jagah 15 working days.
Yes, sir.
Fair enough?
makes sense. Yes.
Yes, sir.
Okay. Next.
Sir, I would like to say something maybe very silly, but the
No, ma'am, don't hesitate and don't use the word silly. Every question has the same value, and we respect and honor the every question.
Thank you, sir. Sir, actually, for creating the email address from which the communication is sent to the service providers, that should be organized. The thing is, yesterday we received an email from proceedings. On seeing that, it was shock. Like few seconds, we are getting some shock on seeing what proceedings from IBBA. But it was just sharing of some PPT. And it's a thanks message for participating in conclave.
Exactly.
And one message, show cause notice received from IBBI. The show cause notice is being received from an individual email address, some person's email address. Anyway, it is followed by IBBI only. But however, there is no such authentication is not there.
Good suggestion. See, proceeding, they are using that email ID for the CIRP proceeding work, where we had to submit everything to the board. Then we had to submit it CIRP.IBBI something. Okay, that's the proceeding email ID. And from there only they send if there is any queries, they use the same email ID. But your suggestion is very much valid, that for inspection there should be a common, in spite of individual named email ID, there should be some common inspection@IBBI, whatsoever it may be. There must be some common.
May I-
One
Yeah.
observation under section this clause 8,
Yeah.
subclause 1, the
Okay.
proviso. Provided that where the investigating authority is satisfied that notice will cause undue delay in investigation, or I mean, this is looking like a police power. This is looking like a police power, a CBI power type of a thing, that you can just land up and I don't know why this is required. It's a civil, our work is essentially civil in nature, and why is this required? But,
Oh,
who
yes.
is going to be the competent authority to
Investigation authority.
decide that the noticee may destroy things and stuff like that?
Exactly.
What is the level of officer in IBBI who
Yes.
would be
Yes.
empowered to waive this notice period?
Yes,
there should be some kind of.
there must be some mechanism like under income tax. If there is some 148 cases, then they have to take the special permission from the commissioner.
Something like that, because
Something like that.
otherwise, this is looking almost like a police power.
Is the arbitrary power has been given to IBBI.
It looks like a police power type.
Yes,
It's not,
that's a very valid. Yes, that's a very valid suggestion. Nitika, kindly note it down. It's a very valid point. We should remove this proviso.
Okay, sir.
We should suggest to remove this proviso.
Okay.
Or otherwise,
what is the mechanism?
Otherwise, there must be some mechanism under what circumstances which enforce the investigating authority to take such step. Very valid point. Very valid.
There are other investigation authorities which can cover this investigation under IBBI also.
Sorry, Rajeshji.
The investigating authorities are already there, which cover the subjects of the investigation, which may come under IBBI matters also. So they can.
That's true. That's true. But here there must be some mechanism. Should be there in black and white.
Right.
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 Any other suggestion? Under point number regulation 8 clause 3, investigating authority may visit the office of the service provider for conducting the on-site investigation after giving the due notice and fix the time with the service provider. Suppose service provider is at out of station and they say we are coming at your office, and after reaching the office, investigation authority will say we are in your office. So prior
that is proper. That is proper, because
Yes,
ultimately otherwise it becomes like a raid.
Exactly.
It becomes like income tax raid or
Yes.
CBI raid, ED raid.
Yes. Next.
It should be treated as a civil matter.
Does any parallel authority like SEBI have this kind of a arbit power? Where is this coming from?
SEBI has the power of inspection and investigation as well.
No, that is true. But do they have something like they can raid it and things like that, just like this?
No, but they can attach the accounts and all that thing.
No, that they can. That I know SEBI can after an order. But can SEBI just raid it?
So that's why we are giving the suggestions. They should remove that proviso, or there must be some
proviso has come from somewhere. I'm sure this proviso has come from somewhere.
See,
it's not.
It is the regulations, not the act, not the code.
But they may have taken a reference from some other authority who may be having this, it is better to study that also.
Yes, 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 yes.
Can,
So that
does
will be
RBI have an authority like this?
no.
Does SEBI have an authority like this? They are all sector regulators, right? Does
Right.
IRDA have an authority like this? Does PFRDA have an authority like this? You know, if none of the sectoral regulators have an authority like this, why should this sector regulator have an authority like this?
Fair enough. We can raise this our queries before the High Court.
So my suggestion is that,
Inspection part.
hello.
It should be
Yeah,
very
Mr. Bakshi. Yeah, Mr. Bakshi.
relating to the process of CIRP.
It should be
Specifically related to the process of CIRP or liquidation.
obviously.
Not beyond the scope
Not
of
beyond that. Not beyond that.
what is being done in the process of CIRP.
Yes. Not beyond that.
The other commercial matters which are otherwise.
No. They don't have any authority beyond IBC. Yeah, Mr. Balaji.
Yeah, actually, my suggestion is that the date of inspection should be decided in consultation with the service provider.
Yes. That we have already mentioned.
Yeah, that's.
Next, Nitika, next. Next. Any suggestion on 9, regulation 9?
Can you just scroll up a bit? Oh, एक proviso और था. Let us read that proviso. एक मिनट इधर. थोड़ा और नीचे जाइए. There is one rather biggish proviso I read somewhere. These provisos are dangerous, you know, in law.
There is no other proviso.
Can we look at that interim investigation report?
Yeah.
ठीक है जी.
See, my point there is, I was also investigated, but I never, I got a show cause notice some 7 or 8 months later.
Okay.
The interim investigation report was not shared with me at all.
Okay.
So does it say
Yes.
anywhere over here that it will be shared with
Yes,
the person?
under regulation 9(2), submit an investigation report.
Yes, but it is
required
where
by
does
the
it?
board.
Yeah, but where does it say it will be shared with the person who's investigated?
There is one more just above it. Every search or seizure shall be carried out in accordance with the Code of Criminal Procedure 1973, 2 of 1974 related.
Very true.
What is this?
See, here we have to mention that under regulation 2, sub-regulation 292, that the report shall also be shared with the service provider.
No, sir, go just one above that. Investigation report ka upar jaiye. Clause number 13.
Okay.
Every search or seizure shall be carried out in accordance with the provisions of the Code of Criminal Procedure 1973, 2 of 1970, relating to search or seizure made under this code. So is this saying that IBBI also has a police authority?
No. They don't have the power of, but kindly see the earlier proviso. If
यहाँ पे देखिए लिखा हुआ है search and seizure.
नहीं, kindly see the earlier proviso.
अच्छा, police officer. अच्छा.
They will apply to the local authority, local court, and from there they will take the order for the seizure of the documents, whatsoever it may be, and then only they will do it.
It means, in my point of view, it means that seizure will be done in the manner as the police officer does in a one case.
Yes.
But this is the procedure which has been defined in the.
Yes, that is the procedure defined under the CRPC.
But my suggestion, one more is that, sir, these all the rules have been made for the against the IP. If the IP is feeling some problem with the system and he want to say something and he want the resolution of that, but no authority is there to do so.
That's true. That's true. I am 100% agree.
Suppose that the COC is
But it is in all the government department.
not a matter of the government department. We are all the professional and we are working
Yes.
under one board.
Yes.
And you have given a very, very big responsibility to a IP. Because of that, in the whole of the UP, in the whole of the system,
in one
there
of
was
the
one liquidator only in the whole of the UP.
yes.
And you have made a number of the
we have
liquidator and the
completed
resolution professional for that. And you have given the charge of whole company to him.
Mr. Agrawal, you are very much right, but there are other side of the coins also.
Yeah.
There are all fingers are not equal. There are many persons, I know them personally. What happens? They did some things wrong, and after that they arrange a fire in their office, and then said that all our records has been burned. So, see,
I'm not saying, my suggestion is that.
Yes. So we have to see.
If the IP is doing wrong, you take the action. If
Exactly.
the IP is genuinely feeling the problem with the system and he want to share with
There
so
must be,
we will go for that.
There must be some grievance mechanism that we will cover under the grievance act.
No, it is not a matter of the grievance. Suppose that I'm giving the one example of that. Suppose the IP is going, CRP is going on. Publication is to be done and money is not there. And service provider who has published the publication, he's asking the money and giving the 30 to the IP, and the IP is going to the IBBI, IP is going to the agency also. But nobody is helping to them. So what kind of thing?
Sir, in that case, you have to file application. You have to file application before NCLT.
What is going on? You have filed application before the court. Court will give the time to the other party to give the reply. Then he will give the time for the.
So that is a legal procedure. We should not go.
This is a legal procedure, but the solution is not there. Question is
that's why I'm saying that's why I'm saying.
Sir, please listen to me for the 2 minutes only. Suppose that the security agency is working for the security of your property. Nobody is making the payment to him. He cannot do the security. One day he will withdraw the security and the things will be stolen. Who will be responsible for that? That all the material which was important has been taken away by the somebody else.
But in that case, you have to be proactive. IP has to be proactive.
In which manner that he will do that proactive?
Sir, you can contact me. We will discuss it separately. We have handled a lot of cases in that way. So, any other suggestion in Regulation 9?
No, again, I am trying to. I had some practical issues on the Regulation 9. And I'm trying to bring that out.
Yeah, please.
Like, I was investigated in June of last year.
Okay.
In March, I get a show cause notice.
Okay.
Nothing in between.
Right.
So if this interim investigation report and others are at least shared, then at least you are, prepared, for that. Because after show cause, you're aware what you have to reply to the show cause, take a personal hearing, and then wait for the order.
That's why
Right.
he suggested that under sub-regulation 2, the investigating authority shall submit an interim investigation report to the service provider also. That's our suggestion, to incorporate that word, and there must be a timeline under which the investigation shall be completed and final report shall be submitted, and that final report shall also be shared with the IP.
Correct. In my case, it took 9 months.
Yeah, in every case it is there, sir. In every case it is there.
Okay.
Next, investigation report.
Here, actually, I just wanted to bring to your notice, sir. I'm Kalpana. So,
yeah, 9 or 10, Regulation 9 or 10, Kalpana.
Yeah, no, not actually. It's regarding the show cause notice. Actually, when they issue the show cause notice, immediately they will suspend the AFA. Instead of that, once you receive the explanations for the show cause notice, if it is not satisfied, or after issue of final order from the so they can suspend the AFA, right?
Yes. I am very much agree with you.
Yes, and you're not even intimated about the suspension.
Exactly.
There is no intimation at all. Exactly.
Even it's our fundamental right of opportunity of being heard.
Yes. That is
So
not
it's-
at all there. No
Yes,
intimation
yes,
for
yes.
suspension.
That's the arbitrarily power they are using, and we should avoid that thing. So that's why we are mentioning that interim report as well as final report they have to share with the service provider also. And AFA shall not be suspended till the final decision of the DC.
Thanks.
Next, regulation 10A. Next. Here, regulation 11.
Consideration shall consider the inspection report provided under regulation 6 or investigation report as expeditiously. But where is the outer limit? There doesn't seem to be an outer limit to this expeditiousness. There should be some time limit, I feel.
Definitely,
Because
there should be time limits.
there should be some time limit, maybe 15 days, whatever, you know. But the whole process should not take a huge amount of time.
The word expeditiously is very vague. It gives ample enough powers to the board actually, to decide on their will and pleasure.
So there should be some time limit. With
There must be a timeline. There must be a timeline. When board has fixed the timeline for VIP, then there must be some timeline for the board also.
Yeah, maybe 10, 15 days, whatever.
30
something.
days, 1 month, 2 months, something is there.
But there should be
Sir,
outer
something,
limit.
sir.
Yeah.
In all the organizations, the laid down guidelines are there, sir. In all the organizations, the pre-decided guidelines are there. In our organization also, it is better.
That's why we suggested there should be some mechanism of appointment of investigation authority, appointment of inspection authority, then proviso for AFA, cancellation of AFA. There must be some mechanism, and that should be shared with the service provider also.
And there must be some outer limit also. Outer limit, this much time it has to be complete. You verify any of the organization, either public sector, private sector, there must be some outer time limit. It must be 3 months, it must be 4 months, otherwise it is a
some limitation shall be there.
never-ending process.
Sir, it becomes essential. The reason being, if you keep the AFA suspended till such time the report comes out, then the onus is on you that you should bring the report also. What is expeditiously? You should have a time limit by when. Otherwise, you don't suspend, do the AFA suspension thing. No, sir.
That is our valid concern.
Yes, sir. This must be mandatory. That there must be a time limit specified. Very valid point.
I'm agree, Kabirji. I'm agree with you.
Yes, sir. Thank you.
Next. Show cause notice.
These things are pretty standard.
Yeah. Next. $15 days, 15 working days.
Yeah, there should be 15 working days, and second, again, that whole point that during the show cause notice,
Sub-regulation 3,
the AFA should not be suspended. This is the
that we have already mentioned.
Main thing
Sir,
with
AFA shall be suspended after the decision of the DC, not before that.
If the DC finds the person guilty,
yes.
Go ahead and suspend, or you can just sometimes.
Moreover, IBBI should not publish the name of the person that we have suspended the AFA of this person. Bad names goes in the industry.
Yes. Yes, it creates some bad reputation also.
Yes, after that, after the DC, after that order of the DC, then only the AFA shall be suspended.
And that is also if the DC decides that this person is guilty. If they
After the order of the DC, that's why I mentioned after the order of
if
the
they levy a fine, and the person is paying the fine, where is the question of suspension of AFA? If the person is really guilty of some big offense or whatever, something, so then too you can even suspend his AFA registration for 6 months, 1 year, whatever you're doing.
Exactly.
Why punish the person before pronouncement of guilty?
I'm agree with you, Mr.
So this is something we should be, forcefully put up with some degree of this thing. This is a must.
So Nitika, can we do one thing? We can arrange a poll, and then we can suggest, see that 100% participant has asked for the timeline and asked for the this AFA suspension after the DC order.
Okay, sir, I'll create a poll.
Yeah.
And initially suspension of AFA, it is not the natural justice, sir.
Exactly.
You see in any organization, the culprit is going to be punished after the all the examination judgment is over.
Sir, I am 100% agree with all of you. This is a major concern for the IP community.
Particularly professionals, because what happens, see, in service, if you are suspended, you are still given something called a sustenance wage. So you get half your salary. Okay. Now here, where is the salary?
Mr. Khetan.
Yeah.
Do you know why they started suspending? I heard from somebody that is because IPs are not taking this seriously. That's why they started doing this. Okay. Of course, majority of us take it seriously, but
see, we cannot move away the black ships. Right. So,
So in that case, sir, it could be like this. If the person is not responding within the stipulated time, then suspend.
Yeah, that's a good suggestion.
Yes.
If the person, so supposing we have given him 20 days to respond, okay, and he is not given any response in 20 days.
That's a good suggestion.
Also, we can have something on the lines of the.
Yeah, otherwise they can mention that if you will not respond within 15 days, 20 days, then your AFA shall be keep in suspended position.
Yeah, after that you suspend if the person is not given.
Yes.
Yeah, you can mention that in subparagraph 4, which says that if you fail to respond, it will be disposed of based on material, and there you can mention that the AFA will also be suspended.
Yes. Then only their AFA can be suspended.
Sir, maybe we can have something like plea bargaining.
But Pankaj, if you suspend the AFA and while the proceedings are ongoing, there is CIRP going on something, how would the person act,
See, AFA, it is clearly mentioned whatever assignment you are in your hand as the on date of suspension of AFA, that will be moving on. You cannot, AFA means you cannot take the new assignment.
Could continue.
Yeah.
You cannot take the new assignment.
That's correct.
Yeah.
So going on the same thing, if somebody gets suspended, when there is an adverse order, this is something I always wondered. What happens to these existing assignments in that case? Of course, they give a copy to COC. COC may decide to replace him, but otherwise, does he continue with it?
Yeah, they will continue. They can continue. Yeah. Next, Paul is ready. Nitika.
Yes, sir. Just give me 1 second.
Yeah. So share any other suggestions in meantime. See, they are mentioning that under the show cause notice, they will provide the inspection report or investigation report finding with the service provider.
Yeah, that is right. At that time you get it, but that's some 6.5 months later. You know?
Yes.
And see, and there are chances that some items may have been left out there, or some items relates to a previous RP, and then you don't have to go and argue against that in your reply to the show cause.
Exactly. That's why in inspection and investigation regulation, we mentioned that report shall be shared, whether interim or final, with the service provider.
Right.
And show cause after the giving the due time to the service provider, then only AFA shall be suspended after the show cause notice. Yeah, Nitika, ready? Please.
Yes, sir. I'm just launching.
Yeah.
I think, sir, there is some issue. I'll launch it in 5 minutes. Maybe we can discuss
Then
go forward.
move further.
So after this, it is only the personal hearing, right?
Exactly. Disposal of show cause notice. Suggestions, please.
The personal hearing part, I didn't see it.
Opportunity of being heard is there, na?
Where?
Clause 1. After providing.
Okay, great.
Yeah. I think it is okay.
Yeah.
Next, Nitika. Kindly share your suggestions. Our suggestions will be put some weight on IBBI. So be open and suggest whatever you can.
I think this is pretty straightforward.
I have one query, not exactly inspection, not exactly show cause, but I had received 2 years before one email from, I think, IBBI about that some CD's director had made a complaint against me, which I replied, and thereafter no communication from IBBI. How do I know what is the situation?
Why to bother, ma'am?
No, but I have to report in the half-yearly return whether there is any proceedings going on.
No, there is no proceeding has been started against you, no, unless and until notice has not come.
Yes.
It's a routine. It's a routine inquiry.
Okay.
Simple thing.
Okay.
Any suggestion in this restitution? Next. I don't think any case has come under this regulation 14 restitutions till date. Simple. Next, now come to this inspection and investigation regulations are over. So I think we have covered all the regulations for our suggestions. Anything else we want?
Yes, sir. One case, sir. This disposal within 6 months.
That we have mentioned.
Why not it be
already
reduced to
mentioned.
3 months?
Yeah, Mr. Ravi, that we have already mentioned.
Fine. Okay.
There must be a upper time limit.
Pankaj, 6 months is too long a time.
Sorry?
Not only too long,
6 months is too long a time.
Sir,
Yeah,
6
and-
months is too long a time, sir. It should be reduced to 3 months. Why
Not
they
even
want 6
that.
months?
Not only that, if you are, suspending the AFA, then 6 months becomes very painful.
Yeah, that's true. That's true. But where is 6 months?
I think in IPA there is 6 months. IBBI says 30 days.
Under regulation, maximum DC order is within 35 days.
Yeah, 35 days. IBBI is
Yeah.
35 days.
Yeah,
The IPA has 6 months.
IP has 6 months, but they don't suspend the AFA. Na?
No, they do. They do. Ask
They do,
Nitika.
sir. They do.
Yes, sir, we do. Sir, the rules are same.
And one more thing, sir, why
That should not be the 6 months. That should be the 35 days if rules are the same.
Then why it should be 6 months then, Nitika?
Why it is 6 months?
It should
And
be
one
at
more-
par. It should be at par, Pankaj. It should be
Yes,
at par.
yes.
Sir,
And
I think,
A sub-regulator cannot
Uh-huh.
have a higher time limit than a regulator, right?
Exactly. That's
sir, I
because.
think.
Yeah, Nitika, please.
Sir, I think there is a complete procedure, like firstly, SN will be issued, then the IP will reply within the specified time. Then there will be disciplinary committee meeting, there will be personal hearing, and then only the decision will be taken. And this will take some time. That's why the maximum time of 6 months is mentioned.
No, but this is, in this case, IBBI says 35 days. They do this all within 35 days.
Sir, I am not very sure whether the complete proceedings, like everything is completed.
But
in
after
30
SCN,
Okay.
35 days. See, your pre-investigation and all that is, of course, you're going to do, you will take time. Let's say 1 month you take for investigation or inspection, whatever. And then you prepare your interim report. Then you ask for the comments of the other IP. Then you prepare your final report. Then eventually, if you decide to issue the SCN, in that case, that should be disposed within 35 days.
Very true.
And one more thing, sir.
It is only
Within 6
fair.
months, IPA wise, how many cases they are disposed of, sir? Within 6 months time? IPA wise, any disclosure is there?
Yes, sir, we generally do within 6 months only.
No, madam. My question is, particular question is, suppose you are discussing 6 months. In how many cases you are taking more than 6 months?
But generally, we try to complete it within 6 months only.
No,
Yeah, but
Nitika's
any
question
time-
is how many cases you have taken 6 months,
Okay,
That
sir, it
time,
depends. Sir,
analysis.
okay, sir, it depends on the number of SCNs we have issued. It's not like every 6 months we do that.
No.
So-
My question is, any analysis you are disclosing in the quarterly wise or half yearly wise, any disclosure is there from IPA side? During
Yes, sir.
this quarter,
Sir-
this much cases taken up, this much cases closed.
Sir, actually, in the journal,
In public
we
sector,
are. Yes, sir. In our ICSI IP journal, we mention that we monthly report the insolvency professionals what we have done, like how many inspections we have done, how many disciplinary cases we have disposed of. So it's a monthly data which we publish in our journal.
In journal, it is published.
Yes, sir.
Now, Nitika, come to grievance part.
Yes, sir. Sir, actually, the poll, there is some technical issue. So
No
I'm
issue,
unable
then,
to-
Pankaj,
One
Pankaj,
more request,
Pankaj, may
sir.
I add one thing?
This
May I add one thing?
the suspension.
One by one, please. Yeah, Mr. Gowda.
The suspension guidelines has to be reviewed overall, sir. Overall, the suspension guidelines has to
Suspension
be
of
reviewed.
AFA, na? Suspension of AFA.
AFA and IPA also suspension or lifetime suspension.
ये आपने 5,200 जो पेमेंट किया है उसे आ गया कि लेना बाकी है?
Okay. ठीक है. Well taken. Yeah, Mr.
Because suspension is the last word, sir.
अपना फीस आ गया
That is not the initial word. Any organization, suspension is the last word, not the initial word, sir.
Yes.
That you have to
आपको बोला है
all the stakeholders have to take note. Suspension is the rarest of the rare.
Yeah, fair enough, Mr. Gowda, fair enough. Now, Mr. Khubchandani ji, you are telling something?
Pankaj, I was saying that, once these disciplinary proceedings and all investigation, everything is over. Now, if the action is to be taken for violation or something, I think in cases where, the bona fide cases where there is unintentional or, there is, innocent, violation, first, case should be, warning should be given, and then subsequently, but I've seen in many cases, straight away the penalties are levied or, there is a suspension. But in most of the cases, I've seen that. So first, in first instance, the warning should be given. If that is repeated, then maybe, strict action should be taken by the regulators. But, in the first instance, most of the cases I've seen, where it is unintentional or, this is bona fide, this thing because of maybe, you can say, lack of understanding or something.
Yes. I'm agree with you. Moreover, kindly see the data during from 2017 to 2022. Whatsoever order DCA has been given, all has been stayed by the different high courts.
No, that stage should not come. I mean, in the first instance, the warning should be given in such like cases.
Exactly. That's why the DC should not be so harsh if it is not the willful default. See, intention should be
correct. Agree with you. Correct.
Intention should be judged by the DC. They should not go by the timeline and point-to-point things. Their practical problems shall also be considered by the board.
Yes, practically it should be seen, It should not be, one should not go by the rule book.
Exactly. So there are totally different in practical approach and in theoretical approach. So
correct. Sometimes, the circumstances warrant, that some action is to be taken. I mean,
exactly.
bona fide.
Next, now we move.
Ritika,
kindly mute Mr. Bharat Upadhyay.
Sir, one thing, I just want a clarification.
Yeah.
Regarding frivolous and malified complaints against RP or IRP, is there any?
See, whatever complaint has been received by the IBBI, as far as my knowledge is concerned, they ask for the evidence first from the complainant. And if there is no substantial evidence, then they never issue any clarification mail to IP. Am I right, Nitika?
One point is many times complaints are made against RP to gain time.
Yes, that's true. That thing we have to explain when the mails come, what action we have taken against that complaint.
But then some burden should also be on the complainant in case of frivolous or malified complaint.
That should be there. Sir, that should be there, but the IBC cannot cover the individual person. Most of the complaints came from the home buyers. Mr. Bharat, kindly mute yourself.
Hello.
Yeah, Mr. Singh.
Actually, sir, the language of the order against the IP, I think that there should be an improvement, because their wording in order, it is like they are treating a child. Okay. And second thing is that if any complaint IBI is receiving, it should be shared with to the IP. If that kind of complaint we have received against you, what is your say about that? Because that is, there is too much problem with the IP to focus on the giving the answer or what do you think?
Yes, Mr. Anilji. That's why we said there must be
not able to hear you. Mute. Pankaj sir,
Sir,
we are not
you're
able to
mute.
hear you, sir. You are on
Oh,
mute.
sorry. Whatever, now the inspection investigation regulations are over, and whatever suggestion we want to give further, kindly mail to the ICSI IIP. Now we will move to Insolvency and Bankruptcy Board of India grievance and complaint handling procedure. That's
Can you please increase the size little more to have the readability?
Yeah, Nitika, kindly do. Now it's fine. So regulation 1 is okay, I think.
Yeah, that's okay.
Okay.
Regulation 2 under definition clause. Any suggestions?
Okay, 2 is okay, definitions only.
Yeah, please.
Does the stakeholder also includes the IP?
Stakeholder?
Service provider means when a service provider, that means an IP also.
IP, yes.
IP can also make a complaint.
IP can make a complaint against the COC.
Against the promoters, against
But
the
it is not specifically mentioned in that stakeholder definition.
No, it says a service provider. IP is a service provider, basically.
Service provider is there.
Okay, right.
It is ambiguous. It is ambiguous.
Yeah.
Service
No,
provider
it's
can
not
be anybody,
ambiguous.
you know.
Sir, it's not. Kindly see
But
the.
it is not explicit, sir.
No, it's written. It is written.
Mean service provider means just go before that I clause. It is there. Then regulation 3, stakeholder who wishes to file a grievance shall file with the board.
Yeah, that's okay.
Next.
Details.
If any stakeholder has issued a grievance on a service provider, immediately IPPA should not give that grievance portion to the service providers. At least they have to look into it, that grievance, whether that is valid or not. Instead of simply forwarding and getting the explanation.
Yes, Kalpana ji, what is there? See, nobody want to take any responsibility on their shoulders. So whatever mail they receive, they immediately forward to the service provider. See, we IP are very strong as per the.
Correct.
So we cannot do anything in that. We cannot make regulation for the conduct of working of the IBI.
Always the timelines will be the service providers, not to the IBBI.
Yes. Yeah, already decided by the Honorable NCLT that timeline is not for the dedicating authority. It is not mandatory. I think regulation 4.5 is okay.
Yeah.
Okay, sir.
Regulation 6. It's the practical approach. Within 30 days, that 30 working days, we can keep it. Sub-regulation 3 of regulation 6. $30 days of receipt of it. Okay. 30 days is fair enough.
30 days is fine. I mean, faster it's done, better.
Yeah. Next.
Here it has given the 30 days time to service providers, but after that, whether that grievance portion is fully closed or not, how we will be able to know, because there will not be any communication from the IBPA.
Yeah, that's a valid question from Khetan.
Ma'am, generally after closing the grievance, a closure letter is given to both the parties. It's a practice.
Okay.
Is there any timeline for that closure portion? How when
30 days, ma'am, 30 days only. So we'll have to close the complete grievance within a period of 30 days only.
It is mentioned now. Board shall close the grievance within 30 days.
Hmm.
See now what the board do? Board has empowered this duty to IPA.
IPAs, yes.
Next. Yes, board may forward a grievance against an IP bylaws and intimate the within the 30 days of receipt of grievance. Clearly mentioned here. Next.
I think this is pretty straightforward.
Yeah, simple. Next.
Okay, there is a fine of 2,500. Refund the fee. Okay.
That should be increased. That should be increased. 2,500 is a peanuts. I think that should be around 10,000 or 20,000, something like this.
No, sir. Let's see the other side also.
That's why I'm saying, no, otherwise the frivolous complaint, it will keep on coming. In the home buyer case, thousands of complaints come.
If the threshold limit is 1 crore, it should
Hello.
It should be more.
Hello.
25,000 rupees.
Hello. Hello. Yeah, at least 25,000. I agree.
Yeah.
Hello.
So, Nitika, we can do here regulation 8.
Hello.
We can keep it 2,500, 25,000 or more. What the board feels comfortable.
Hello.
Next. Statics next.
Some statistics.
It's covered. Yeah, I think it is covered now. Now we can, forum is open for all participants to discuss related to inspection, investigations, grievance, whatsoever we can give the suggestions. And
Committee, disciplinary committee. See, it is only one member whole-time director. It can be a member from the concerned IPA and also another member who is a senior IP can be selected at random.
Yeah, that we have already suggested in DC. There must be 3 members. We have already given the suggestions for that.
Yeah, that's good.
Yeah.
Hello, actually, sir.
Yeah, Mr. Singh.
Actually, anybody who are making the previous complaint against the IP and the IP suffer too lot. Okay. I want to section 182 applicability on that fellow person who are making the previous complaint. The IP has the right against section 182 for he are providing the false or wrong information as the IP. He can take any action against him if IP thinks that he unnecessary tease and make problem for IP. There is some 182 declarations will be there in under IPC to that fellow person.
Okay. So what's your suggestion?
My sir, there should be 182 IPC. There should be there. Even anybody making false accusation, if it is found false, the against should be taken against him. Section 182.
No, Mr. Singh, complaint is not coming directly to you. Complaint is coming to IBBI.
Sir, IBBI will taking against section the IP. Na, he is facing problem.
They will not take immediate action against the IP. They will adjudicate the things, whether the complaint is valid or not. There must be some evidence with that complaint. And then IP or board will ask from the service provider, if this complaint has come with the board, what is your saying on this complaint?
Sir, that is okay, but the IPBI is not the adjudicating authority for determining these things. If if IP suffered due to the bad decision of the IPBI, so if if there is the because IP suffered, so IP can take this in the next level, na? That I approve that.
Hey, Mr. Singh, how the IP will suffer if he has not done any wrong thing? Then how the IP will suffer?
Sir, support won't give too much give to the IP by putting everything is in giving information, everything
No. See. Then if you come with a clean hand after the DC order, if you come with a clean hand, then you can file the case for defamation against that person who barred you.
Yeah. So there is should be 182 section I4
Sir, everything CRPC, CPC is already there. No one barred you to exercise that thing.
No, that is okay thing. There is a format, sir, complaint and
yeah.
The IBBI should put a section IPC 182. If anything action is, you find your allegation is wrong, so action against you take in future.
No, sir. IBBI cannot do. In this case, I don't think any other IP will agree with you. Any suggestions on Mr. Anil Singh Patwal view?
No, sir. Thank you very much.
Please, Mr. Singh, please elaborate what is the concrete suggestion?
They are, he is saying that under the IBC, there must be CRPC 182 mentioned that if any frivolous complaint is there,
IPC,
then
IPC 182 section is there. If anybody making the false information, so that is the right of the person. He can take against section 5.5.
Section 182 of IBC deal with appeal to the Supreme Court.
As far as provision for some deterrent, I agree there should be some deterrent provided. Like initially
we have suggested for the monetary. We have suggested for the monetary penalty should be raised from 2,500 to the 25,000.
I think that should be good for now.
Yeah. And once you come with the clean hand, if any IP come with the clean hand with the DC order, then you are free to file the defamation case against that person. No law barred you.
Sir, one other suggestion could be when a person is making a complaint, that complaint could be, that complaint should be followed with some kind of affidavit saying that all the information that is being provided by me is best to my knowledge. In a way, it gives some kind of legal sanctity to the whole process. The person may be slightly discouraged to make false complaints if that is, one way to address it.
Right. That's
Pankaj, I agree.
That's a very valid.
Affidavit should be submitted along with the application.
Yes, good suggestion. Nitika, kindly note down. Along with the prescribed form, there must be some affidavit on oath that shall be submitted along with the. Otherwise, what will happen? Unknown name person will come and
people will start misusing the entire thing.
Make a complaint, and along with that, their identity proof shall also be taken.
Yes.
Who is making the complaint?
And so one more suggestion I had is, does it make sense to include some kind of generic language in the text to say that principles of natural justice would be followed in the course of investigation? Basically to give some kind of opportunity for the other side to, rebut some kind of incriminating situation.
That is there, Mr. Porwal, that is there.
Okay.
I board when make the interim report, then they ask for the clarification. With the show cause notice, they ask for the clarification on their observations.
Sure, makes sense. Yes,
that is there. And for the disciplinary committee, they also opportunity of being heard is also being given by the board.
Sure, thanks.
So I think this is Shalini here. I am also an RP. I think it is the suggestion about affidavit or identity proof of the complainant is very important. Only those complaints should be taken into account because there are a number of anonymous allegations which float around. So this could be a very important suggestion.
Along with the valid email ID, contact number, And there must be some witness of that affidavit also.
Sir, I think this disciplinary committee is only quasi-judicial.
Yes. That is a quasi-judicial. See, DC is working as a quasi-judicial body, na?
So, when it is quasi-judicial, what will be the sanctity of demanding an affidavit?
Yeah, that problem is there.
Be involved in it. Simply, we cannot suggest. We are also IPs. We know certain legal things, if not fully. Before suggesting, have a rethinking on that.
Okay.
Quasi-judicial authorities are not supposed to exercise the judicial powers.
But we can.
Yes, very true. Very valid point.
On non-judicial stamp paper.
So I think your first suggestion of increasing the fee for filing the complaint may be a deterrent, you know. So unless someone is genuinely grievanced by the RP, they will then not, for any frivolous reason, file a complaint.
Right.
Stamp paper wala thing, I think Mr. Madurai Sundar, I think Sundaramji is right, because affidavit quasi-judicial authority के सामने तो लगता नहीं है वैसे.
No. So the form of the identification can be discussed. That is not the point. That whether it should be on stamp paper or not. But the identity of the complainant should be known.
Yeah, that is right. The complainant must disclose the identity and whatever evidence that person is having. The identity must be disclosed.
There is no problem in asking for an Aadhaar card or a PAN number, whatever it is.
Yeah, something like that.
Yeah, that is the point. That point was not about judicial, non-judicial, etc.
Yeah, can we suggest that there must be some declaration sort of thing under the form?
No, Pankaj, I would suggest affidavit. I would suggest affidavit because it will be a deterrent for the frivolous complaint.
But we have to see the legal point also. Some Mr. Madurai has suggested that affidavit is for the judicial and DC is the quasi-judicial body.
No, even Pankaj, even these if you go to any gas authority or any other electricity office, they ask for the affidavit in case of there is a duplicate license to be issued. So when these authorities are asking for driving license replacement and renewal, what is the harm in submitting the affidavit for this thing?
Affidavit on, see, I am not from the legal background in practice. So what's the difference in non-judicial and judicial stamp paper? Can we do it on non-judicial stamp paper?
No, there's a legal sanctity on the non-judicial stamp paper.
Then legal sanctity, na?
Many authorities insist for affidavits. It's a normal thing.
Legal sanctity, otherwise on a plain paper.
That's why I'm saying if we mention that affidavit on non-judicial stamp paper, then it will serve our purpose.
Yes, very much.
In any case,
Actually,
Pankaj, most of the states, the denomination of non-judicial stamp paper is 2 rupees or 5 rupees. That's it.
No,
or maybe 10 rupees.
It is almost 100 rupees.
Okay.
Not for affidavit. Not for affidavit.
No, affidavits are sought even by government department. That's a true. It's a fact of life. Many of the government departments, central, state, they insist for affidavit for many things.
But denomination can be fixed like 2 rupees or something, 5 rupees, 10 rupees. That can be fixed.
That is based on the respective stamp duty. Stamp duty is a state subject. Whatever is the stamp duty applicable in the respective state, it is applicable.
Exactly.
So
correct, but in most other states, it's 2 rupees or 10 rupees or 5 rupees.
No, I would say it is 200, 100. That's what normally in the states.
Our purpose is to suggest something.
Anyway, it can be on the plain paper, but it should be notarized or this thing that can be notarized also.
So that language should be drafted in such a way that no legal reports come.
Sir, it can be drafted also because many departments have the pre-drafted affidavits to be given to many applications, registrations. It is normal. Both for central and
along with the form, we can our board can draft that language.
Exactly. And that somebody said identity is very must. See, there is something called OVD, officially valid documents as per Reserve Bank of India.
Yes.
Yeah, any of the OVDs can be.
Otherwise, though, frivolous unknown complainant will come and waste it.
Exactly. Yeah. Which does not accompanied by identity should not be accepted by IBBA.
Exactly.
On these things, shall we have a statistics of how many frivolous complaint has come and how many frivolous complaint have been taken into account for consideration?
Hey, come on. Let us not waste. Let us not bother about it.
No, we are talking something hypothetically and suggesting certain things. Unknown of the real facts. See,
I think Nitika is the best person who can reply.
In government parlance, when the officer concerned feels that this is a frivolence, he will simply throw it to dustbin. No action.
Nitika, does we have any statistics of frivolous complaints?
So right now, I don't have that with me,
Okay.
but we actually receive frivolous complaints, and generally whenever an email also is received by IBBI from any person, we actually take that in consideration. We actually send emails to that person, and if that person does not reply with the complete details, then we generally close. But we actually receive frivolous complaints.
Okay, so it means
so Pankaj, so that's why I'm saying, this affidavit or this declaration would act as a deterrent to these frivolous complaints.
Exactly. And one more thing.
And even if it is on the plain paper, let it be notarized. Let it not be on 200 or 100 or
yes.
It should be notarized.
In many cases, what happens is unknown person sent a mail to IBBI. So without any proper form or without paying the fee, just they send the mail. So I think the board or IPA should not consider that frivolous mail.
Sir, one thing.
Yeah, please, Mr. Ravi.
Sir, this online redressal grievance mechanism should be made 100% online compliant.
How? Kindly explain.
Mails are entertained. Many frivolous complaints can be reduced. Timelines can be maintained. Disposal will be easy. Our statistics will be perfect. Likewise, we don't know how many complaints received, how many frivolous, how many attended, all those things, and it will be faster also.
So, Mr. Ravi, why to bother VIP? It's not our cup of tea. Why to bother everything? How many frivolous complaints are coming with the board?
But sir, we have the data, like every IPA and IBPI, they have the
that
data. We generally,
there, but it is not for VIP, na?
That's right. But
why to bother so much, yeah?
And sir, just for the information, the grievances are generally completed in 30 days because we have to give the report to IBPI, and IBPI, they have to give the report to MCA. So these grievances are actually being tracked on every month basis, and there are like IBPI and MCA. They also ask why within 30 days the complaints are not disposed of. So this is being taken care of by all the authorities.
Very good. So any other point of discussions?
Is the frivolous complaints are from the same person? If it's multiple application, frivolous complaints, any action already taken, or is there any plan to take action against frivolous complainant?
Yes, that's a good question, Nitika. If any person again and again make a complaint without any evidence,
sir, maybe we cannot control the other person. That other person is not under the guided by the regulations.
But if any person is bothering you by filing frivolous complaints again and again on the same subject.
Sir, if in one subject the case is closed, then we do not entertain for the same subject matter the same.
But you don't entertain, but you have to read that mail. Your time will be wasted.
Yes, sir. Maybe people can suggest.
Yes.
You are discussing a good subject, but under what provision you will penalize?
Sir, we will. It's not the provision of penalization. But there must be some some guidelines or something in black and white should be there. If any person is making frivolous complaint again and again and again.
Sir, you cannot stop those fellows.
Sir, that's true. But there must be some.
Yes, I'm telling you, in practice, out of my experience, you cannot stop a fellow who always throws some bit on someone. He will keep on doing it. That is his nature.
That's true. That's true. That's true.
And you have no concrete provision in any of the law to do anything with him other than defamation case, which you can find. That the individual capacity they may have to do.
That's the individual capacity.
Yes.
Okay. Fair enough. Any other point? So I think
we cannot control that complaints again from the same person, but IPA can restrict. They should not entertain those complaints from the same person again and again.
Okay, fair enough. So I think we have given enough suggestions for the regulation of grievances and inspection and investigation. So thanks all of you for giving your valuable suggestions, and Nitika will compile all this and will send the mail. So over to you, Nitika.
Yeah, thank you. Thank you so much.
Thank you to all the participants, and thank you, Pankaj sir.
Thank you.
Thank you.
Thank you. Thank you all. Thank you.
Thank you, ma'am.
Thank you, sir.
all.
Thank you.
Thank you.
Thank you very much.
Thank you. Thank you. Thank you. Thank you.
Thank you.
Thank you very much.
Thank you.
Thank you. Thank you.
Thank you very much, everyone.
Thank you.